DiCristofaro. I'm chairwoman of the Ohio Democratic Women's Caucus. We're here today because we recently found out about another incident which has shocked us all in the Attorney General's office. Yet again, this involves the senior leadership, and it appears to have been handled in an unusual manner. Here's what we know. An assistant AG in the employment law section repeatedly made threatening and violent comments to a legal secretary. He was given probation and still works in the office today. He said things like, "You know, you will do your job or you will be smacked. And you know, there's nothing more fun than smacking a woman, that is, except for punching them." Somehow, this man still works as an attorney in the AG's office. Timothy Lechleiter, a senior DeWine aide and head of the employment law section, apparently knew of the harassment and was initially disciplined for not reporting it. However, he was given an unusual opportunity to have the case reinvestigated, and then it was overturned. When he was made aware of the harassment, Lechleiter reportedly told another supervisor he didn't want the section to become a no-fun zone. Now, this is appalling. We'll discipline you, but we don't want this to become a no-fun zone. There are important questions that still need to be answered. Is Mr. DeWine's office a culture that's safe for women? These cases have shown a pattern of disrespect for women by senior DeWine aides and other DeWine employees. Are these the only incidences that exist? We've now seen women in subordinate roles victimized twice in DeWine's tenure. Both cases involve senior DeWine aides who were never identified or ever punished. And in both cases, there's a pattern of looking the other way and meddling in internal investigations. How is this possible that the head of the employment law section didn't understand his obligation to report threats against an employee? Does the office culture permit this type of behavior? Was Mr. Lechleiter, who also serves as Dublin City Council, afforded special opportunity to have his case reinvestigated because he's a prominent Republican official in Columbus? Was this politically motivated? The only way Ohio women will get satisfactory answers to these questions is if they are independently investigated. A few weeks ago, we also delivered over 1,000 signatures to the AG's office demanding just such an investigation of the office's sexual harassment case. Based on this new case, we again are asking Mike DeWine to commit to a fair, thorough, and impartial independent investigation of how his office handles cases such as workplace harassment. Mike DeWine owes Ohio women an honest answer. Thank you.
Thank you, Kathy. Thank you, Kathy, for your leadership on this, and I'll just simply echo some of what Kathy had to say. I mean, it's certainly appalling facts that we've heard, and this is now more than once that we're having this conversation. It's at least 2 times too many, and I'd say even more than that. To have words, this is the year 2014. This is not the 50s or the 60s. This is not Mad Men. But we're seeing what looks to be a culture in this office that looks far too much like the old days, where people got away with talking about women, talking to women, and in some cases approaching women in ways that are completely inappropriate. And so we have this pattern that's very clear, and then we have a pattern that's also clear of investigations into such inappropriate behavior, incredibly both times just sort of disappearing or going away, and that's also inappropriate. So as Kathy said, the words spoken to the legal assistant by someone in the employment law section about smacking and punching women are just horrific. And the idea that this was not responded to immediately by the supervisor is just frankly startling. Let's be clear, the employment law section is exactly what it sounds like. This is the part of the office that guides state agencies around the entire state about how to avoid harassment, about how to create a culture of women being respected in office, in whatever workplace they're in the state, and to have, of all places, the employment law section, the one where not only is violence being spoken to women employees, but supervisors for month after month. This went on over a matter of months. The first complaint, I think, arose in March of last year, and it wasn't until July that anything was done about it. So this woman was literally approached, apparently almost on a weekly basis, repeatedly being told things by a male employee that he thought punching and smacking women was fun or funny, and that if she didn't do her job, he would smack her. I mean, again, what in the world is going on in this office? So I agree with what Kathy said. There needs to be a really close look into not just this incident, but a number of these incidents. I just want to go back for a few seconds and talk about the big picture here, because this is not an isolated incident. I want to go back a couple years. In Steubenville, there were 3 young men who watched violence occur, did nothing about it, tweeted about it, laughed about it, photographed it, and back then the Attorney General's office told them that although they hadn't behaved correctly, they didn't commit a crime. And women, I think, across this country were alarmed by the Attorney General's conclusion that doing that wasn't a crime. Then we have a case at almost the exact same time as this case of a young woman, an intern who was harassed by a senior level person in Mike DeWine's office. And that investigation took a very strange turn. First of all, it was not initiated the correct way. And then a few months into the investigation, when it finally was on the correct path, the Attorney General himself demanded to meet with the investigator, met with the investigator, over her objection, demanded to know who the confidential informant was, completely inappropriately, and then he met with the confidential informant. And then the investigation never led to a result. And if you read the transcript of which I have here, of the discussion between the Attorney General and the investigator, it's almost surreal. He says to the investigator, "I want you to give me the name of the confidential informant." And by the way, the person who the intern had accused of being a harasser, she described as a friend of Mr. DeWine. But Mr. DeWine insists on getting to know the name of the, quote, confidential informant. The investigator says, "I'm sorry, that would be inappropriate to give you the name." And even after she says that, he demands to get the name, and she gives it to him. Over the course of that investigation, another interview was done where they were looking for who might have done the harassing. And another senior level person of Mike DeWine's office was described by a colleague as someone, this was a different person, senior level person in the Attorney General's office. One of Mr. DeWine's right-hand persons was described as someone who, to this person, it would not be surprising if this person did anything inappropriate within this office. This is another employee that has an issue. And then we have this case at the same time in the employment law section, who is saying words of violence towards a woman employee, and a supervisor of the employment law section who for months knew that and did nothing about it. And finally, I would say it's very odd, worse than odd, to have an Attorney General interfere and demand a confidential informant. And I know he has told folks like some in this room that was okay, and that was okay for him to do that. Absolutely, it's ridiculous that he did that. It's completely inappropriate that he did that. Any current day sexual harassment lawyer would tell you a boss has no business interfering in an investigation if his friend is the alleged harasser. And that was inappropriate. I also believe if you look closely at the rules in the current Attorney General's office, this idea that once the head of the department, Mr. Lechleiter, was found to have violated policy, if you read closely the Attorney General's policy on harassment investigations, there is a right to appeal, but it isn't the respondent's right to appeal, it's the complainant's. So this whole idea that Mr. Lechleiter got to have an appeal, if you read the policy, there is no provision that he gets to appeal that finding. The only person who has the right to appeal is the employee who is claiming they were harassed against. The office policy says very clearly, the complainant has 10 calendar days from receipt of the notice of the report to begin the internal appeal process. If the complainant fails to notify the office within 10 days of his or her desire to engage in the internal appeal process, the matter will be considered closed. So somehow the person who the finding was against got to appeal, even though the policy says the appeal is only for the complainant. So you add all this stuff up, and we're talking about major issues that is repeated over and over again in the last 3 years. Violence and harassment against women in this office is happening, and investigations now on more than one occasion are going way off the rails inappropriately. So I will do several things, and I echo what Kathy said. But we think both these cases need to be independently investigated. And I also, when I arrive as Attorney General, we will do a full-out review of the policies and practices of this office when it comes to harassment in the workplace and how it's investigated. And we will bring in outside experts to make sure that beginning in 2015 and beyond, the women of this state and the women who work for the Attorney General's office can be assured that they will have a climate and culture free of harassment, and that will come down very quickly, very hard on any sense and any actions that look like harassment or violence or the like. It's just simply unacceptable in 2014 to see the repeated things that we're seeing here. So with that, I'd love to open it up to any questions people might have, but obviously we take this very seriously.
David, the office said every employee of the state is granted and has the right to due process, and that someone who's accused has the right to challenge that. What do you make of that argument?
All I can tell you is I'm reading the policy that they have in place for this exact kind of investigation. And that policy looks to be as clear as can be, that it's the complainant that gets to appeal, and if they don't appeal in 10 days, the case is closed. So the policy that Mike DeWine, his name is on it, only provides for an appeal for one side and not the other. And that's all I can tell you. I would just say, to echo what Kathy said, let's think back for a second. There are 2 instances of harassment here. In both instances, the victim no longer works for the Attorney General's office. And in both instances, the culprit still does. That's startling in 2013. 2 separate instances. Victim is gone from the office. The woman who was abused or victimized by that kind of language, no longer there. And somehow the Attorney General hasn't figured out how to get rid of the people who are doing the harassing, or worse. That's a real problem. But in terms of that policy, I think I'm just reading what is under Mike DeWine's signature title here. It says the complainant has a right to appeal. It doesn't mention anything about an appeal for the respondent.
David, we got about 15 days left until Election Day. What do women who are registered to vote, or women who are registered to vote and have minors that they're responsible for? What are the conclusions that they should draw from this case now that it's coming to this kind of head shortly before Election Day?
The truth is, I think women and men, frankly, both should be very, very troubled by this. Again, this is the employment law section of the Attorney General's office. This is the section that's, I gave a speech 2 weeks ago at the City Club. It was supposed to be a debate, but one person didn't show up, so it was a speech. And part of what I said was, I will use the employment law section to develop the best practices so that workplaces across the state workplaces, are free from harassment. This should be the place that's leading the way in explaining to bosses all over the state and workplaces how it is that you actually are a workplace free from harassment. So it's especially awful that the employment law section is the one where words of violence were uttered for months to a woman employee, and the supervisor never did a darn thing about it, and said something as bizarre as you can imagine, that he didn't want to have a, quote, no fun zone in the Attorney General's office. If I were Attorney General, those people would be out. And I would use this office as the leadership role that it needs to play to actually make the workplace across Ohio one where we see equal pay and harassment-free workplaces.
Obviously, this office was heavily publicized under a previous Democrat for the sexual harassment issues there. What's to say this wasn't just a culture that has continued since Mark Dean?
I mean, I think it's frankly doubly surprising that you still see that happening in this office when this was such a big issue only a few years ago. If you would think there'd be one thing that Attorney General DeWine would have fixed, it would have been this problem. And so the idea that only a few years later you are seeing such deeply troubling quotes, facts, investigations that are clearly botched or taken off the rails inappropriately, and inaction in the face of just horrible words said to employees. I mean, it says a lot that the first thing you think would have been on the list to solve, which was an office that had a reputation of not respecting women, is still not solved. I think is deeply troubling as well.
One more.
Any other questions? Thank you all very much. I appreciate it.